Judgment in the appeal for Queen on the application of AA against the Secretary of State for the Home Department.
Lord Toulson will announce the decision of the court.
This appeal is about the legality of the appellant's detention for a period of just under 2 weeks in July 2010. He was detained under the Immigration Act 1971, Schedule 2, paragraph 16. Under that paragraph, immigration officers have the power to detain someone if there is reasonable ground to suspect that he is liable to be removed from the UK as an illegal entrant, pending a decision about his removal or the implementation of removal directions. There is no dispute that this applied to the appellant. However, by Section 55 of the Borders, Citizenship and Immigration Act 2009, Parliament made it the duty of the Home Secretary to see to it that regard is paid to the need to safeguard the welfare of children in the area of immigration and asylum. The appellant asserts that in his case there was a breach of Section 55 which made his detention unlawful, and he claims compensation. The facts can be summarized shortly. The appellant was born in Afghanistan. He arrived in the UK in October 2008, concealed in a lorry. He was caught and arrested. He claimed asylum and said that he was aged 14, but to officials he looked to be older. An age assessment was carried out by social workers from the Children's Services Department of Hampshire County Council. They concluded that he was aged over 19, and that was reported to the Home Office. At that stage, he was released from detention while the Home Secretary considered his asylum claim. The asylum claim was refused, and he appealed to an immigration judge. In March 2010, the immigration judge dismissed the appeal, and in the course of his determination, he too found that the appellant was aged over 18. Soon after that, the appellant solicitors wrote to the Home Secretary challenging the way in which the age assessment had been carried out. They also asked Hampshire to do a reassessment. But by this time, the appellant was living in South Wales, and Hampshire suggested that the request for a new assessment should be directed to Cardiff City Council. Cardiff agreed to do so. On the 7th July 2010, directions were set for the appellant's removal from the UK on the 20th July, and he was detained under paragraph 16. If the Home Secretary had believed him to be a child, he would not have been detained, because it is the Home Secretary's policy only to use her detention powers under the Immigration Acts in the case of a child if the circumstances are exceptional. However, the Home Secretary reasonably believed that the appellant was aged over 18 because that was the view which had been formed by the Hampshire social workers and by the immigration judge. On the 20th July, the day set for the appellant's removal, his solicitors issued judicial review proceedings against the Home Secretary, Hampshire and Cardiff, who had not yet carried out the new assessment which they had agreed to do. On the same day, a judge granted temporary relief, and the appellant was released from detention into the care of Cardiff. Soon afterwards, Cardiff social workers carried out a new assessment. They were critical of the Hampshire assessment, and they concluded that the claimant was in truth under 18. The Home Secretary accepted the new assessment, and so it is now common ground that the appellant was in fact a child at the time of his detention. His claims against Hampshire and Cardiff were compromised, and the sole remaining issue is whether the Home Secretary had acted unlawfully in detaining him. Section 55 says that the Home Secretary must make arrangements for ensuring that the functions mentioned in the section are discharged having regard to the need to safeguard and promote the welfare of children who are in the UK. The relevant functions include any function of the Home Secretary in relation to immigration and any functions conferred under the Immigration Acts on immigration officers. The section also says that any body exercising those functions, which means principally immigration officers, must have regard to any guidance given by the Home Secretary for the purposes of the section. The Home Secretary has given a good deal of detailed guidance in various published documents, including detailed guidance about how to set about the task of assessing the age of a person who is seeking permission to stay in the UK. This can be a difficult task, especially if the person has no reliable identification documents. The appellant's case is that Section 55 means that in the case of any child, his welfare must be taken into account when reaching a decision whether to detain him. In his case, he was a child, and no consideration was given to that fact in the decision to detain him. Therefore, his detention was unlawful, and it is no defence for the Home Secretary that she reasonably believed on the material before her that he was over 18. The Court does not accept that this is what the section says or what it means. The true effect of the section is that the Home Secretary has a duty to make arrangements for seeing that regard is had to protecting the welfare of children when decisions are made under the Immigration Acts. Those arrangements included detailed and careful guidance about age assessments. There was no breach by the Home Secretary of her personal duty under the section. There is, in truth, no perfect way of eliminating altogether the possibility of an erroneous assessment, but the guidance contains a number of checks, and there are also checks in the Court's own supervisory powers. The guidance attempts to minimise the risk in a way which is reasonable. Further, the guidance was properly applied by the immigration officers in this case. Therefore, there was no breach of Section 55. The detention was lawful, and this appeal is dismissed.
Thank you. The Court is now adjourned.